Hello, it's Mark Chatterton of Charterhouse Chambers, and I want to talk to you today briefly about employment. Not employment law, of course, because I'm not an employment lawyer and I'm not interested in all of that, but I am interested in the status of an employee and how it impacts on health and safety and the application of health and safety law within the workplace. Well, things used to be fairly straightforward when most people were employees. We've always had difficulties, for example, with the docs cases, and there's been some weird and wonderful relationships, many of them tainted by illegality when it comes to construction workers. But increasingly, the old-fashioned relationship of employer-employee no longer applies. So many people are on 0 hours contracts or are self-employed or look to be self-employed and provide services. And of course, there are an awful lot of agency workers, even amongst the big employers, and certain factories, whole sections of them, can be manned by non-employees of the factory owner of one sort or another. Well, what are the relevant factors? Relationship, obviously, between the employer and the person working for that person. There may be a contract of employment. That would be nice, wouldn't it? Because that will give you a complete answer. But let's assume that there is not. It really is a question largely of control. And often the question is put in this way: is the employer entitled not only to tell the employee what to do, but the way in which to do it? If the answer to that is yes, then we're likely to be looking at an employer-employee relationship. If the answer to that is no, then in all probability we are not. Another way of looking at that little conundrum is, to what extent is the proposed employee a highly skilled and specialised person, brought in perhaps to do a certain job that the employer is not in fact qualified to do himself. If that is the situation, then the likelihood is that the person is an independent contractor rather than a servant or agent. All of these things, frankly, are on their own facts. And some other factors can be, well, who provides the tools, who does the risk assessment, and who, as it were, takes the risk, who controls the way in which the employee works. Can the so-called employee say to the so-called employer, well, I'm not coming along to do the job for the next week, but my brother, who is just as skilled as I am, he's going to come along and do it instead. If that person has the right to say that, then frankly, they're not an employee. There have been a number of cases over the years on the point. Lee Ting Sang versus Chung Chi Kyung in 1990. Very useful case that established that a casual worker on, I think, a building site was in fact an employee. But the case that has really with us today is Lane against Shire Roofing in 1995, which concerned, perhaps unsurprisingly, a roofer. And the roofer was sent by Shire Roofing to do a small job on, I think, a porch roof. Was told that he really ought to use some scaffolding, but decided he didn't want to use scaffolding. He'd work from his own ladders. Pause there, his own ladders. He decided that he wanted to do the job as he saw fit rather than as he had been told. Sadly, and in circumstances very mysterious, he fell and sustained a head injury. One of the problems with the quite interesting judgment in Lane and Shire Roofing is there was no direct evidence in relation to the circumstances of the accident. The defendants sought to argue all sorts of things, but they sought to argue that he was not an employee, but he was a skilled subcontractor. They simply failed and were told no, he had all of the hallmarks of an employee, and he recovered substantial damages from them. It may be that Lane and Shire Roofing is a bit of a high watermark case, but it is still good law. Well, what I hear you asking between your yawns is the relevance of all this. We have not had, since October 2013, directly enforceable health and safety regulations since, of course, the Enterprise Act came into law. All common law. Doesn't really make a difference. Well, yes, it does. To begin with, of course, the duties owed by an employer to an employee are non-delegable duties. So the employer cannot hide behind the performance of a subcontractor. That is hugely valuable. And it really means that if one looks at the non-employer's duty, one's looking at perhaps the Occupiers Liability Act, which of course contains delegable duties. You'll find yourself suing every last person in sight. So what I do in terms of pleadings, if I think that somebody is an employee, then I simply sue in negligence and based upon a failure to perform the duties set out in the regulations. And I do not sue under the 1957 Act, but I think these days it is increasingly dangerous to sue a non-employer without using the 57 Act. In any event, Parliament, to my mind, did not kill the entirety of the regulatory framework by the 2013 Act. To my mind, and I appreciate that it is perhaps an arguable point, the management regulations remain. And we know that the management regulations only applied between employers and employees. They never applied to third parties. And of course, if you lose the management regulations, you lose that most important regulation 3, the risk assessment, which of course underpins it all. In any event, if one is looking at the common law, one is really looking at the regulations in order to work out whether there has been a breach, what the standards are. And some of the regulations, and of course most importantly the manual handling operations regulations, and of course the regulations in relation to PPE, only ever applied between employers and employees. Finally, I suppose there is that perhaps almost forgotten piece of legislation, the Employers' Liability Defective Equipment Act of 1969, which again only applies between employers and employees. But that is a quite separate talk.